This lecture would be devoted towards non-profit organizations and digital personal data protection acts and rules, as the act and the rules they provides opportunities and challenges to the non-profit organizations to work out and introduce the functioning of transparency and accountability. So, in this lecture, we would like to discuss about the data processing consent and data security measures, data subject rights of non-profit organizations. So, the Digital Personal Data Protection Act was passed by the Indian Parliament in August 2023 but is not yet fully operational. While the Act itself is in place, detailed implementing rules and the establishment of the Data Protection Board of India are still pending. The Digital Data Protection Rules and its applications as per the draft aims to provide a comprehensive legal framework for protecting digital personal data in India. So, in particularly, the draft rules as released by the Ministry of Electronics and Information Technology has for the Digital Personal Data Protection Act in the month of January 2025. The government has solicited feedback on the draft rules from various stakeholders, including businesses, non-profit organizations, and the public. The government is expected to release the final rules after considering public feedback and establish the Data Protection Board. Once the Act is fully operational, companies, including the non-profit organizations and individuals, will be bound by its provisions, which include data processing, consent, data security measures, and data subject rights. So, we would like to discuss the Digital Personal Data Protection Rules of 2023 has been introduced by the Ministry of Electronics and Information Technology, Government of India. This was following the enactment of the Digital Personal Data Protection Act of 2023. So, the Digital Personal Data Protection Rules shall come into effect in a phased manner. The exact dates for the implementation of different provisions will be notified by the government, which has assured allowing organizations enough time to adapt their processes to comply with the law. The Digital Personal Data Protection Act, read with the Digital Personal Data Protection Rules, is set to provide a comprehensive framework for digital personal data protection, emphasizing the principles of compliance with the law towards transparency and accountability. As for the non-profit organizations, these rules present both opportunities and challenges. By proactively adopting best practices and ensuring compliances, non-profit organizations can reinforce their credibility and trustworthiness in the eyes of beneficiaries, donors, and all stakeholders. So now we would like to make an overview regarding the very provisions of the Digital Personal Data Protection Act of 2023, and in particularly regarding data fiduciaries in relation to non-profit organizations and personal data and those obligations laid down under the rules and act regarding the non-profit organizations so relating to data fiduciaries. These are entities including organizations, businesses, or individuals that collect, process, or store personal data, and non-profit organization that collects personal data in digital modes can be a data fiduciary under the Digital Personal Data Protection Act. A data fiduciary including and non-profit organization is responsible for ensuring that personal data is handled in compliance with the law. Their obligations include obtaining explicit consent for collecting and processing personal data, implementing data security measures, and respecting the rights of individuals whose data they process. Also, it provides regarding data principle and how the non-profit organizations programs. This data principles refers to the individuals whose personal data is collected or processed. A beneficiary of an non-profit organization's programs whose personal data is collected for monitoring, evaluation, or program delivery is a data principle under the Digital Personal Data Protection Act. And now we would like to discuss the very rights of the data principles. Data principles have specific rights under the Digital Personal Data Protection Act, read with rules such as the rights to access, correct, or erase their data. They are at the center of the regulatory framework emphasizing the importance of individual privacy and control over personal information. So, now we would like to discuss about those implications for the non-profit organizations as such. The non-profit organizations shall be classified as data fiduciaries, since non-profit organizations often collect and process personal data from beneficiaries, donors, and stakeholders, making compliance essential under the Digital Personal Data Protection Rules. Further, the Digital Personal Data Protection Act continues to hold the data fiduciary responsible even for data breaches or non-compliance by data processors and mandates that contracts between data fiduciaries and data processors must reflect this responsibility. And now we would like to discuss the Responsibility of the non-profit organizations towards compliances under the digital personal data protection rules. So, among these, the number one, that the non-profit organizations must obtain explicit and informed consent from individuals who are data principals before collecting or processing their personal data. This consent must clearly outline the very purpose of data collection, the retention period of those data collected, and whether the data will be shared with third parties such as partner organizations, donors, or service providers. Further, implement reasonable security measures including encryption, controlled access, and regular system monitoring. If non-profit organizations rely on third-party service providers such as data processors for data handling, they must ensure these entities also to comply with the same security standards and ensure that they implement appropriate checks of these compliances. Further, the non-profit organizations shall be required to provide detailed information to data principals about their data processing practices. This includes specifying the very purpose of data collection, the rights of individuals under the Digital Personal Data Protection Act 2023, and providing contact details for someone responsible for addressing queries related to data processing. Further, the Digital Personal Data Protection Rules also emphasize data minimization and retention limitation, requiring non-profit organizations to collect only the personal data necessary for their stated purposes. Data must be retained only for as long as it is required by law or operational necessity. Once the purpose has been fulfilled, the non-profit organizations are expected to delete the data, ensuring that unnecessary retention does not compromise individuals' privacy. Also, in case where non-profit organizations process personal data without explicit consent, as permitted by certain exceptions under the Digital Personal Data Protection Act, such as compliance with legal obligations, it must notify the data principals about the processing activity. The notification should include information about the processing and provide a communication channel such as a website or contact point where individuals can exercise their rights under the Digital Personal Data Protection Act. Further, the non-profit organizations shall appoint a data protection officer to ensure compliance with the Digital Personal Data Protection Rules. The data protection officer shall play a critical role in overseeing data protection strategies, monitoring compliance, and acting as the point of contact for grievances related to personal data processing. For non-profit organizations, the data protection officer ensures that data collection, storage, and usage align with the principles of legal compliance, transparency, and accountability. The data protection officer is also responsible for conducting regular audits, training staff, and coordinating with the relevant authorities to address potential breaches or violations. So now we would like to discuss regarding processing data of child and persons of with disability. So in particularly the draft digital personal data protection rules require the data fiduciary to obtain verifiable consent from a parent or lawful guardian before processing the personal data of a minor or a person with a disability. The fiduciary must also ensure due diligence to verify that the individual claiming to be the parent or guardian is an adult and, if necessary, can be identified through reliable age and identity details. For lawful guardians, verification must include confirmation that the guardian was appointed by a court or relevant authority. And further, we would like to discuss about the verifiable consent and tracking of children. So, obtaining verifiable consent and tracking of children under the digital personal data protection rules exempt certain data fiduciaries from the requirements of obtaining verifiable consent and from tracking children and monitoring their behavior in certain cases. The data fiduciaries also exempted inter alia, which are included clinical establishments, mental health establishments, or healthcare professionals when providing health services to the extent necessary for protection of health. Further, allied healthcare professionals when processing of data is to support implementation of any healthcare treatment to the extent necessary for protection of health. And finally, educational institutions when processing is off for behavior monitoring and tracking for the educational institutes' activities or in the interest of safety of children enrolled with the institution. And further, we would like to discuss the exemptions of applicability for research, archiving, or statistical purposes. So, regarding that, those who, when processing for research, archiving, or statistical purposes is carried out, then the provisions of the draft digital personal data protection rules and the act are not attracted, provided that such processing must inter alia be carried out in a lawful manner, be limited to such personal data as is necessary for such uses. Processing in such cases is done while making reasonable efforts to ensure accuracy of personal data, maintaining reasonable security safeguards to prevent personal data breach and etc. Now we would like to discuss about the NPOs, the non-profit organizations and the compliances in regards to conduct a data audit, update policies and procedures, build capacity of stakeholders, leverage technology, appoint data protection officers, and establish communication channel. So, in that connection, those digital personal data protection rules in case of conducting a data audit, the non-profit organizations or NGOs should map their data collection, storage, and processing practices to identify gaps and ensure alignment with the Digital Personal Data Protection Act and the rules. And in regards to updating policies and procedures, privacy policies, consent forms, and internal guidelines should be revised to reflect the transparency and accountability requirements under the Digital Personal Data Protection Act and rules. And in case of building capacity of stakeholders, it must educate the staff, volunteers, and other stakeholders on data protection principles in order to foster a culture of compliance. And in case of leverage technology, it would invest in technology solutions in order to simplify and streamline compliance tasks, including maximizing privacy of data to monitoring data access. And while appointing data protection officer, the non-profit organizations or the NGOs to oversee data protection strategies and to ensure compliance. And further, in regards to establish communication channel, the non-profit organizations or NGOs for that regard, for individuals to exercise their rights under the draft digital personal data protection rules of 2025. So, in this particular lecture, we have discussed regarding the non-profit organizations or NGOs as laid down under the Digital Personal Data Protection Act 2023 and those rules drafted in 2025 in establishing Data Protection Board of India and for requiring data processing consent, data security measures and data subject rights, and it would ensure transparency and accountability of those non-profit organizations as the very act and rules provides them sufficient opportunities and challenges, and how the non-profit organizations are considered as data fiduciaries and collecting such personal data, their obligations, and in regards to that also we have discussed the rights of the data principal and the very implications for the non-profit organizations and the very requirement of compliances under the Digital Personal Data Protection Rules of 2025. And